Good evening, everybody. My name is Christina Fraser, and I would like to bring attention to the subject of forensic psychological evaluations as a tool for determining competency to stand trial, specifically focusing on their use with limited English proficiency defendants or LEP defendants. So let's first start with the law. We could say that everything in regards to competency to stand trial starts with the 14th Amendment of the U.S. Constitution, which establishes three major provisions. The Citizenship Clause granted citizenship to all persons born or naturalized in the United States. The Due Process Clause declared that states may not deny any person life, liberty, or property without due process of the law. The Equal Protection Clause said that a state may not deny to any person within its jurisdiction the equal protections of the law. This immediately brings out the subject of undocumented or illegal immigrants. You may wonder, does the 14th Amendment not apply to them? Is it only U.S. citizens or legal permanent residents? In fact, some may be surprised to learn how far the Constitution extends its protections toward non-citizens once they are inside the country. The 14th Amendment and its extension, the Fifth Amendment, give the right to equal protection under the laws of the United States to all foreign nationals who are present within the boundaries of the U.S. Cases extending back to the 1800s, including ones brought by Chinese immigrants challenging the arbitrary seizure of their property, have established the rights of non-citizens under the 14th and Fifth Amendment, including due process and the right to a jury. Going one step further, Title VI of the Civil Rights of 1964 prohibits discrimination on the basis of race, color, or national origin in any program or activities that receive federal funds or other federal financial assistance. That national origin aspect of it protects individuals with limited English proficiency and requires the provision of language interpreters. When speaking of due process, numerous rulings have established the need to determine that a defendant is competent to stand trial, which is considered a main element when speaking of due process. One of the most cited case law in this matter is Dasky v. U.S. in 1960, which held that for a defendant to be considered competent to stand trial, he or she must have sufficient present ability to consult with his attorney with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against him. In Drobe v. Missouri in 1975, ruled that a defendant's participant in his legal proceeding is essential to an adversary system of justice, which is why evaluations on competency to proceed to trial are fundamental to a fair and equitable justice system. This is further spelled on the Uniform Jury Instructions of Criminal Procedures 41.03. Jurisprudence dealing with this issue of competency to proceed to trial has focused on fundamental fairness, which is provided by the procedural and substantive due process right of pretrial defendant. To determine competency to stand trial, a forensic psychology assessment is often conducted, which can be ordered by a judge, but most typically requested by defense attorneys for the clients. An article in the Journal of Forensic Legal and Investigative Sciences defined psychological assessments as a process of gathering and integration of psychology-related data to make a psychological evaluation by using tools such as tests, interviews, case studies, behavioral observation, and specially designed apparatus and measurement procedures. The mental health profession may use a variety of tools such as semi-structured interviews and empirically validated scoring criteria that are commercially available. These are forensic assessment instruments, forensically relevant instruments, and clinical assessment instruments. Here are some of the examples of those instruments. In his article, El-Shanawi states that the clinical interview is the cornerstone of competency to proceed to trial assessment. He also affirms the first consideration of using traditional psychological tests in forensic assessment is that the given test should have a desirable degree of standardization. Standardization concerns with a standardization group of normative samples, the basis on which the individual test score will be compared, administration procedures, scoring, and interpretation of the results. The Handbook of Psychological Assessment tells us that the group should be representative and large enough to make such comparison. The more dissimilar the person is from this standardization group, the less useful the test is for evaluation. In cases of evaluation of individuals with limited English proficiency, if the evaluator does not speak the language of the defendant, a trained or qualified interpreter must be used to conduct the assessment. It is my position that the standardized quality of an assessment tool ends the minute the dyadic encounter, evaluator-client, ends and a triadic one begins, evaluator, client, interpreter. Standardized assessments are created and administered in English language and based on a specific social group, the U.S. community, with all its cultural, socioeconomical, and educational influences and experiences. The standard quality of an assessment requires that the tool be administered in the same exact way each time, and no help or explanation should be provided to the client. This is not possible when the defendant does not speak the same language as the evaluator. Language translation is not a literal process. When there are no other legal systems that are exactly equal to the United States judicial system, there are no exact words to translate certain terms. Numerous legal terms have no direct or exact translation, so interpreters adopt specific terminology in order to maintain a relative standard across the industry. That terminology typically is the explanation of the English term into the target language. For example, in the case of a Spanish-speaking defendant, the evaluator may ask, "Do you know what an indictment is?" which will be interpreted as, "Do you know what a formal accusation is?" So essentially, the interpreter is providing the answer to the question simply because there is neither an equal judicial proceeding nor an exact term in a Spanish country that is exactly equivalent in meaning to the word indictment. The typical translation for it's the actual definition of the term. Clinical psychologists who conduct forensic assessments are encouraged during training about working with LEP individuals to meet with the interpreter for a few minutes after the encounter to debrief and obtain feedback from that interpreter regarding details of culture or language usage or anything remarkable about the encounter. This can indeed be helpful. However, interpreters who are not trained mental health professionals may offer opinions that can create bias on the evaluator, once again damaging the standard aspect of that assessment. Furthermore, the Code of Ethics of Professional Conduct of Judiciary Interpreters clearly state in Canon 4 that court interpreters and translators shall limit their participation in those matters in which they serve to interpreting and translating, and shall not give advice to the parties or otherwise engage in activities that can be construed as the practice of law. This same standard for interpreters is mirrored in the National Code of Ethics for Interpreters in Healthcare. However, evaluators often use interpreter opinions in their reports. In essence, they are assessing competency outside of standards of a test. In conclusion, it is my opinion that forensic psychological assessments fail to provide an accurate and unbiased professional opinion regarding the competency to stand trial of limited English proficiency individuals. The utilization of these tools in a court of law interfere with the defendant's right to due process. An assessment of questionable validity can potentially deprive an individual of his or her right to life, liberty, or property without due process of law, in violation of the 14th Amendment of the U.S. Constitution and its extension, the 5th Amendment. Lastly, I believe specific tools or assessments should be developed, tested, and validated, but focusing on the characteristics of foreign nationals or limited English proficiency individuals in order to obtain a valid, impartial, and accurate assessment of the individual's competency to stand trial.